Good afternoon, everyone, and welcome to our panel discussion on challenges in monopolization cases. I'm Rahul Rao, the Deputy Director of the FTC's Bureau of Competition, and I have the pleasure of moderating our second panel of the day. Although the topic of monopolization has been at the forefront of legal, academic, economic, and political discourse for well over a century, it feels more relevant than ever today. From global tech companies to local healthcare providers, we see powerful players dominating markets, shaping the way we live our lives and interact with the world around us. And the impact of these dominant firms on consumers, workers, competition, and overall economic growth is undeniable. For the next hour, you will hear from international and US enforcers who will share their experiences in bringing monopolization cases. Through their stories and experiences, we will explore fact patterns that might not fit current doctrinal theories and address the complex task of designing and then enforcing appropriate remedies in single-firm conduct cases. And to be clear, today's panel won't answer all the questions out there on this topic. This discussion is just a sliver of a much broader conversation. Our goal with today's discussion, and the ones we'll continue to have, is to collectively reflect on each other's experiences and to inform a framework for future enforcement actions here and across the globe. I'm really excited to start our discussion, but before I do, I want to introduce our distinguished panelists. To my far left, Olivier Groscent is Director General of the EC's Directorate General for Competition, a position to which he was appointed in January 2020. He joined the European Commission in 1992, where he has had successive leadership positions. In addition to his work at DG Comp, Mr. Groscent has held positions in the private offices of several European commissioners, including serving as head of the private office of the Commissioner for Internal Market and Services. In July 2014, he was named Deputy Director General of the Directorate General for Financial Stability, Financial Services, and Capital Markets Union, and then Director General from September 2015 until 2019. Early in his career, Mr. Groscent served at the French Ministry of Economy and Finance, where he carried out many investigations for the French Competition Authority. He graduated with distinction from the Institut des Études Politiques de Bordeaux. Hetal Doshi is Deputy Assistant Attorney General for the Antitrust Division for the United States Department of Justice. Ms. Doshi is an accomplished trial and appellate attorney with an experience in white-collar, civil rights, and international matters. She garnered that expertise both in private practice as well as nearly a decade in the Department of Justice, where she started her tenure as an assistant U.S. attorney in Denver, Colorado. Ms. Doshi has supervised and conducted both civil and criminal trials, as well as training and mentoring other prosecutors. She served on the Department of Justice's Financial Fraud Enforcement Task Force, where she led investigations of global international banks for their conduct in causing the 2008 global financial crisis, resulting in historic multi-billion-dollar penalties. She also established a cryptocurrency and exotic financial instrument expertise in her prosecution practice. Ms. Doshi has previously served as an advisor and partner to the Antitrust Division's Procurement Collusion Strike Force and has, for the last year, served as the deputy overseeing all civil and criminal litigation for the Antitrust Division. Ms. Doshi earned a BA from Emory University and a JD from the University of Virginia. Next to her is Ki-Jong Han, chairman of the Korean Fair Trade Commission. His 3-year term as chairman began in September 2022. Chairman Han is also a distinguished professor at Seoul National University School of Law, currently on leave of absence as he leads the KFTC, and served as that university's dean from 2020 to 2022. Before leading the Fair Trade Commission, Chairman Han also served on the advisory council to the Constitutional Court and is chair of the Audit Committee of the Ministry of Justice. The chairman earned both a bachelor degree in public law and a master's degree in public administration from Seoul National University and a PhD in law from the University of Cambridge. Finally, to my immediate left is Paula Blizzard, Senior Assistant Attorney General at the California Attorney General's Office, where she leads the office's antitrust law section. Ms. Blizzard supervises all the section's cases and was the lead California attorney for the Sprint T-Mobile trial. Before joining the California AG's office, Ms. Blizzard was Deputy Bureau Chief for Enforcement at the Federal Communications Commission, a trial attorney at the U.S. Department of Justice Antitrust Division, and a partner in a law firm. Now, nothing delights me more than a lawyer with an interesting resume, and on this, Ms. Blizzard delivers. Before she became a lawyer, Ms. Blizzard had a career in aerospace as a NASA contractor working on space station design and NASA's early use of the internet. If time permits, I may ask her why in 2023 my in-flight Wi-Fi continues to be so maddeningly spotty. Ms. Blizzard holds a Bachelor of Science from Massachusetts Institute of Technology and a JD from the University of California at Berkeley. So, we have, at this point, less than an hour. That's not a lot of time to cover an expansive topic like monopolization. So let's just dive right into it. And I want to start with Chairman Han. Chairman Han, the KFTC has been on the cutting edge of tech monopolization cases. A couple of years ago, the KFTC fined Google around $177 million in US dollars for abusing its market dominance in the Android operating system. And more recently, the KFTC fined Kakao Mobility around $20 million US dollars for unfairly manipulating the algorithm in its taxi hailing app to give preferential treatment to its franchise taxis. The KFTC's success in these cases is to be applauded. Could you tell us a bit more about the Google Android case, as well as your case against Kakao?
Yeah, great. It's a great honor to speak, to be invited and speak at this Infosys Summit. In digital markets characterized by economies of scale, platform operators have continued to make attempts to exclude their competitors. Their strategies have evolved to prohibit transactions with competitors, disrupt the business activities of competitors for compatibility reasons, and attempt to monopolize the adjacent markets through self-preferencing after mergers and acquisitions. Today, I would like to explain two cases handled by our agency. First, the KFTC imposed sanctions on Google for abusing its dominance in the mobile market by blocking smart device manufacturers from developing and releasing innovative operating systems. Since the beginning of its business, Google has released code and open source licenses for all to use, quickly attracting smart device manufacturers. As a result, Google's market share reached 72% within 3 years of its release. Afterwards, Google restricted the business activities of smart device manufacturers by forcing them to enter into an anti-fragmentation agreement, AFA, as a precondition for signing Google Play Store license agreement and the early access to Android source code agreement, which are essential to smart device manufacturers. Under the AFA, Google prohibits smart device manufacturers from installing modified versions of the Android operating system that don't meet the compatibility standard of Google, citing compatibility as the reason when, in fact, the AFA intends to restrict the development of new operating systems. And in other words, Google used an open first, closed later strategy, which is gaining market dominance by opening its platform to grow its user base in the early stage of the market and then controlling the transaction conditions of the companies that depend on the platform. Through this strategy, Google has benefited from rapidly increasing its users and blocking the entry of competitors to the mobile operating system market, while reducing diversity and undermining innovation in the markets. In response, the KFTC imposed a fine and remedies on Google, ordering to prohibit the company from forcing the AFA and to revise contract clauses. These measures are significant as they can provide an opportunity to incentivize the innovation of smart device manufacturers and restore competitive pressure in the markets by sanctioning conducts that harm market competition, such as hindering competitors from developing and launching innovative products. Second is the case with Kakao, a leading mobility platform company in Korea. The KFTC sanctioned Kakao for abusing its dominant market position to assign calls more favorably to its franchise taxis, thereby strengthening its dominance in the market for franchise taxis. Kakao, a de facto monopolist in the Korean mobile messenger market, held 92% of the market share just 4 years after entering the taxi hailing service market. Then the company acquired 2 taxi franchise companies, quickly establishing a strong foothold to enter the market for franchise taxis. Kakao manipulated the dispatch algorithms of taxi hailing services used by both franchise and non-franchise taxi drivers to prioritize its franchise taxis for receiving calls, thus discriminating against non-franchise taxi drivers in the taxi hailing services. As a result, Kakao's share in the market for franchise taxis soared from 14% to 74% in 2 years, raising concerns that it could lead to the foreclosure of the competitors and a decrease in the diversity of services. In response, the KFTC decided to impose a fine and remedies on Kakao, ordering that Kakao change its discriminatory algorithms that allocate rides more favorably to its franchise taxis. This is a representative case of sanctioning a dominant platform that enters an adjacent market through takeovers and rapidly scaling its business through self-preferencing. In addition, this is the second time that the KFTC has detected and decided to remedy self-preferencing of platform businesses by manipulating algorithms, following the case with Naver Shopping in 2021. The KFTC will continue to strictly enforce laws to address monopoly issues in the digital market and improve related systems. In particular, our agency will keep a close eye on platform operators that block market entry and disrupt the business activities of competitors, and that abuse market dominance to leverage market power through self-preferencing. Furthermore, the company will revise law enforcement standards reflecting the characteristics of platforms. To this end, the KFTC established the online platform monopoly review guidelines this January to effectively regulate the abuse of market dominance in the platform sector. The guidelines specify market definition and criteria for assessing market power, considering the characteristics of platforms, and present criteria for determining illegality of conduct that raises competitive concerns in the platform sector, such as preventing multi-homing and engaging in self-preferencing. In addition, our agency plans to revise the merger guidelines within the first half of this year to thoroughly review increased barriers to entry resulting from conglomerate mergers and the possibility of leveraging market power. We are also closely examining the need to improve our legislation concerning platforms and looking at legislation and the implementation of laws of our international enforcement partners. I hope we can take this opportunity to develop a shared approach to monopoly issues in the global digital market and enhance mutual understanding. Thank you very much.
Thank you, Chair. Thank you, Chairman. All right, now we have it working. All right, so I want to turn to Ms. Blizzard. So, Ms. Blizzard, one thing that may be of interest to our audience is the overlapping nature of federal and state antitrust enforcement in the United States. Now, I'll be completely honest, delving into this topic is not just for the benefit of our international friends. I suspect there are many in the US who may find the interplay between federal and state antitrust enforcement to be somewhat baffling. So can you help shine some light on this and give us an overview of the role of state antitrust enforcement and particularly California enforcement?
Yes? Oh, did you have a second question for Chairman Key first? Or do you want me to go? Me to go?
Yeah, Paul, why don't you go?
Okay, let me go? Okay, thank you. Okay, so actually the question I think was about in-flight Wi-Fi. Okay, so plane taking off, there's multiple systems. Some of them are actually contacting geostationary satellites, communication satellites, which are some 30,000 miles up. Some of them are contacting low Earth orbit satellites. Some of them are actually, some of the systems contacting ground systems. This is really old tech. okay? We can keep track of satellites that are so far out they've left the solar system, let alone a plane which is barely in low Earth orbit. In fact, isn't in low Earth orbit, is below that. So why don't we have better Wi-Fi on planes? Because we haven't blocked the airline mergers, people. We need... Okay, more competition. It's nothing but money. It ain't the tech that makes your Wi-Fi drop. It is the fact that they don't have an incentive to put in a truly robust system because, trust me, we can track things that are about this big every second of every day. We can keep contact with a 777 in the sky and not drop your Wi-Fi. If only the airlines had an incentive, which means they need more competition, which means they need to be able to run an ad that says, we will never drop your Wi-Fi, right? That needs to be a competitive selling point. Okay, so there, just bringing my different worlds together for you a bit. Okay, so I'm going to continue to go off script and be difficult. I want to talk a little bit about monopolization and how we handle monopolization in California. A few words on overlapping jurisdiction. We, in the states, we can enforce our state laws, and we can enforce those in state courts or federal courts. We can enforce the federal laws, and we can enforce those, obviously, only in federal court. We have more options than our federal counterparts. We, in general, personal opinion, are more nimble. We are quicker. We have more routes. We have more options. We have fewer headwinds, maybe, to keep us from bringing enforcement actions. But we do have overlapping jurisdiction. And in fact, we have had overlapping jurisdiction for 150 years. Most of the state antitrust laws preceded the federal laws. We were here first, and we have a very long history. And of course, each of the states can go its own way. You can have 50 different versions, which I know drives defense lawyers crazy, but this is the system that we set up over 100 years ago, right? And it has remained the system, and the U.S. Supreme Court, as well as the California Supreme Court, have said unequivocally that we have overlapping jurisdiction and that is, in fact, the most important system. So let me tell you a little bit about what's most important for monopolization from the view of the California Attorney General's office. And that, quite simply, is to use the full breadth of the authority that we have been granted by legislative bodies. We're going to hear a whole lot about new laws. The EU has some wonderful things going on. But I'm here to remind you of the laws we already have. So what did Congress say about monopolization? Who's read the Sherman Act recently? Okay, what does it say? It says, every person who shall monopolize any part of the trade or commerce among the several states shall be deemed guilty of a felony. I'm going to say that again. Every person who shall monopolize shall be deemed guilty of a felony. Now, what doesn't it say? It doesn't say you need a market definition. It doesn't say you need a market share of 70%. It doesn't say you need a balancing test. It doesn't allow for pro-competitive justifications. It doesn't even say the conduct has to be unreasonable, and it certainly doesn't say anything about it being garnered through superior skill and industry. All those things have been added by cases via judge-made law, but it is not the scope of what Congress originally set forth. There's nothing wrong with that, of course. We have very broad rules in this country that are then developed through judge-made law. Many of the things in our Bill of Rights, the freedom of speech, doesn't give you the right to say absolutely anything anywhere, as we all know. But the sense is that Sherman Act interpretation from this incredibly broad law that says every monopoly is a felony, Sherman Act interpretation has only gone one way, that every decision has narrowed it and narrowed it and narrowed it. It's a one-way ratchet in some ways, to the point where it is hard to reconcile some of the decisions today with that very broad law about every monopoly being a felony. Think about the monopolization cases that you work with every day. How does it trace back to that language? So I'm going to tell you a little bit about how the California Supreme Court handles novel fact patterns and how the California Supreme Court handles interpretations of very broad language like this. Now, the case I'm going to talk about is called In Re Cipro from the California Supreme Court in 2015. And it's actually about a restraint of trade, an agreement, but the principles could apply just as easily to monopolization. So the court begins by noting that, quote, although the antitrust laws are framed in superficially absolute language, deciding antitrust illegality is not as simple as identifying whether a challenged agreement involves a restraint of trade, because every agreement concerning trade restrains it. Okay? So it's starting from this general principle that the laws are very broad and it can't literally mean what it says. So the California Supreme Court then walks through how the various courts have created the rule of reason, the per se rule, quick look. But the court's point in doing this is that these are just tools that have been developed by judges. They're not parts of the statutes and the laws as given to us by our legislative bodies. So what the California Supreme Court holds is that strict categories of analysis are not required, but rather what is required is an inquiry meet for the case, looking to the circumstances, details, and logic of a restraint. So it takes the analytical approach, and it says it's a continuum from per se to rule of reason, with the circumstances, details, and logic dictating how the courts should analyze it. In lieu of an undifferentiated, one-size-fits-all test, courts may devise rules for offering proof or presumptions to make the rule of reason a fair and efficient way to prohibit anti-competitive restraints and to promote pro-competitive ones. So in this case, the California Supreme Court goes on to develop what it calls a structured rule of reason, okay? Because it starts from the very broad premise that what is laid down by the legislature is very broad but needs some narrowing, but the narrowing has to be specific to the case before you. It is not a category. So it develops a structured rule of reason for the facts before it, which replaces the traditional balancing test with shifting presumptions that are tailored to what was before it, which was a reverse payment patent settlement. Many of you have heard of those. And it defines what a prima facie case would mean, and then it shifts most of the burden to the defendant to justify the restraints. So it devises an inquiry to meet the specific circumstances of the case to provide a fair and efficient way to prohibit anti-competitive conduct and to promote pro-competitive conduct. So I put to you, as we go forward and look at these novel fact patterns, we have a tremendous amount of leeway given to us by the legislature. We need to propose specific rules, presumptions, burdens that will meet the circumstances of the case. Now, I can't leave monopolization without talking a little bit about California's unfair competition law. I will tell you it's older than the FTC's Section 5, and in fact, it's older than the FTC. It's also broader, it's also better. We are not one of the states that has our law patterned on the FTC Section 5. Our unfair competition law originated in 1887 to enforce basic rules of, quote, common honesty and accepted business ethics. And that was later expanded to enjoin also, quote, unfair practices. California courts have recognized that our legislature intentionally framed the law in very broad language to address, quote, the innumerable new schemes which the fertility of man's invention would contrive. The California Supreme Court has stated in interpreting our unfair competition law that when a scheme is evolved, which on its face violates the fundamental rules of honesty and fair dealing, a court is not powerless just because the scheme is an original one. A court must not lose sight, not only of its power, but of its duty to arrive at a just solution. So, I can get any fact pattern under that language, under our unfair competition law. And in fact, it is specifically designed to address the new schemes, the new ideas. And just because it's new doesn't mean it doesn't violate a law from 1887. So a few closing thoughts on monopolization and how to take these cases. Go back to the text, go back to what it says, right? A monopoly is a felony. Now, it clearly can't mean that, literally. Please don't misquote me to the press in the audience and say I'm arguing all monopolies are felonies. They're not. But the judiciary has a tremendous amount of leeway to devise these tools and rules for things such as defining a prima facie case, rules for offering proof, burden shifting, presumptions, all of these to make the inquiry meet the facts of the case and to make it fair. So that's what the judiciary does. What do we in this room do? We are prosecutors. Our role as antitrust prosecutors is to step up and ask for those rules. Ask for those presumptions, the burden shifting. Don't be afraid to say, yes, Your Honor, this is a new way of looking at this program, this fact pattern, but here's why it's right. Here's why it's fair. Here's why this is what most comports with the congressional or legislative intent behind this statute. So, in short, how does California address novel schemes and monopolization? We enforce the laws. Thanks.
Thank you, Paula. We may come back and ask some follow-up questions, but I want to turn things to Director General Gerson. Earlier in my opening remarks, I commented how we're applying fact patterns maybe outside of traditional doctrine. And so I wanted to ask you, are there particular business strategies that are harmful to competition that do not fit into the traditional foreclosure and exclusion frameworks? And do you have an example of a case that the agency that DG Comp has pursued that did not fit exactly into the foreclosure and exclusion framework?
Press, good afternoon, everybody, and thank you for the invitation. That's quite a question. Well, we're all enforcers, aside from the journalist, maybe, in this room, and so we know that enforcement is a constant challenge of adapting to market realities and to new practices. And of course, it's even truer in the field of digital. So this means both using a traditional analytical framework, but keeping it evolving, and sometimes you have genuinely new patterns of behavior or market situations, and you need to adapt to it as well. Just to give a few examples, zero-price markets. When we adopted our still current market definition notice in 1997, it virtually did not exist. There is not a line in the guidelines on zero-price markets. And of course, this is now becoming something really big, for which we have a lot of enforcement records. The role of data as well as a barrier to entry or expansion, and the way it can be weaponized in anti-competitive conduct is also something that is new and needs to be accommodated in the framework, in particular in the context of multi-sided markets, which is also something that has always been existing, but is a lot more common and more multi-sided, I would say, in digital than in the real economy. And it's more complicated as well. Take the ad tech cases. Well, in the good old world, I remember when I was a young case handler for the French back in the 80s, I made a big investigation into the advertising sector. And it was very simple. I mean, you had the agencies, you have the people that were buying the space, as they call it, and you have the people willing to advertise, and they had a relatively simple contract. Look at the way the same function is now organized in the ad tech world. It is a string of very complicated relationships. It's complicated technically, and it's complicated legally as well. So this complexity is also part of this challenge. So that means adapting the instruments. So, for example, we are now on the verge of adopting our new market definition notice. A lot of the new bits in it, the core is very conventional, but a lot of the new bits in it is precisely related to digital. We have published just today a revised guidance on the enforcement of Article 102, and I'll come back to that towards the end of these remarks. But also sometimes you need to be a bit more radical in your change, in your thinking, and that's why we have the Digital Market Act, because we thought that some of the challenges would be best addressed with a completely different instrument. Now, Raoul, you asked for concrete examples, so let's go into some concrete examples. The first one I'd like to take is, Chaminade has taken already, is Google Android. I think it's a very good one. In Google Android, at least the Commission was pursuing 3 different theories of harm. The first one, very conventional, tying. And actually, a lot of the practices we uncovered in the last 20 years in the Commission are not very sophisticated. You know, tying, bundling, none of this has been invented by the platforms. It was existing before. It's just more complicated in the context of the digital economy. The second one was the revenue sharing that was made conditional on not installing competing apps. And the third one is the one Chairman Ann already referred to, and is the most novel one, the most interesting one, and is the one related to the so-called AFAs, the anti-fragmentation agreement. So let's maybe spend 2 minutes on this. So the context is Android is open source, so in principle firms can develop their own variant as they see best fit. That is the so-called Android fork. And the AFAs basically means that the manufacturers were in effect tied to Google's version of Android. Otherwise, they would be prevented for a number of efficiencies, in particular, the access to Android's App Store. So that's the thing, and it is interesting because, again, as Chairman has alluded to, it's a reflection of this so-called open first, close after strategy. It's not really new, but it's not so common. The last time we had done it was actually in Microsoft for the server infringement, in which Microsoft in the beginning was completely open and to the interoperability between the servers and Windows. And they gradually degraded that interoperability to gain a position on small servers. And once they had it, they continued to downgrade, going up in the size of servers. So opening first captures the clients, and then started to leverage the power on your core market. And that is really something that is very typical of the relatively new strategies you can see in the digital world. So it may look obvious from now, but if you go back in 2018 when we adopted the Google Android decision, and if you look at the comments in the legal community, it was being seen as very daring, and few people would bet we would win in court. We won, and it's now relatively established. Now, very quickly, platforms on the one hand, of course, they have an interest in maximizing the number of business users, because this is what makes their ubiquity, and this is what they derive their power from. And in that sense, they have no incentive to foreclose. On the other hand, they may have an interest to favor their own services downstream. Sometimes they do, as we saw, and marginalize competitors on these markets, or impose unfair trading conditions. And then the question, back to the core of your issue, is it exclusionary or is it exploitative? And it's not that easy. Well, it's actually a bit of the two, and that very much depends on the specifics of the case. We are faced that difficulty very recently. You may know that we have adopted a new statement of objection in Apple Spotify very recently, a month ago actually, in which we refocus the case on exploitative, away from exclusionary, which was very much the focus on the first SO, because we believe the case is stronger that way. But it is really a difficult call. because the truth is that these practices have features of both exploitation and exclusion. In Facebook Marketplace, and also in our Amazon case, you have a different type of abuse, different theories of harm, where the terms of conditions authorize, well, in the case of a marketplace, Meta to use the ads-related data that they collect to the benefit of their marketplace app. And it was a bit of the same in the Amazon case, in which Amazon was collecting the data of the clients, the business clients selling on Amazon, in order to be more competitive with their own offer. So that's also a relatively new type of behavior that you don't find in the traditional economy. So, as I said, you have several ways to adapt to this. Well, the first one is, of course, the cases themselves. They're challenging. And at some point, you have to systematize a little bit your approach. And that's what we're trying to do. We will issue now in a few months or a new market definition notice. Today, we have launched this process of revision of our 2008 enforcement guidance for 102. And what is it about, really? Let me give you a couple of examples what we're doing in this revised guidance. The as efficient competitor test, for example. Well, in a way, we made our own misery, because, and that's a good lesson, is try not to issue guidance when you do not have a solid record of enforcement, because you have to guess. But sometimes you have no choice. We will have to give guidance on the DMA before having implemented the DMA, because firms need to know. But you have every chance to be wrong very quickly and have to review your guidance. And in 2008, we wanted to give the signal that we wanted to move towards a more economics-based implementation of 102. And we might have overdone it a little bit. For example, by suggesting that we would conduct an as-efficient competitor test in all cases. And there are cases in which it's not very well suited. Let me give you a very practical example. Recently, one of our cases was annulled against Qualcomm. It was annulled on pure procedural grounds, so it's irretrievable, I'm afraid. But that's a pity, because, I mean, the really interesting question was, Qualcomm had a monopoly on the said product, a real monopoly, and nonetheless, it found it useful to grant exclusionary rebates. My submission is that, and this is what we say in the guidance, revised guidance, is that in such cases, you shouldn't have to conduct an as-efficient competitor test. The same way where the conduct in general is actually geared to prevent competitors to ever become as efficient. So that's really something that is important to us. It will be followed by a more broad review, for which we were launching a call for contributions. The second thing that I'd like to mention, and I will conclude with this, related to this revised guidance, is about refusal to supply. In the EU, following a case law called Bronner, we have a test for refusal to supply that is indispensability. And because of previous guidance was maybe not as precise as it should have been, there was a bit of confusion as to what it would entail. So what we clarify is that a so-called constructive refusal to supply are not subjected to that very stringent test. And even less, and because that was clarified by the case law, margin squeeze, because margin squeeze is not, in a sense, constructive or not constructive refusal to supply. So to wrap up, I mean, we have this constant challenge of adapting. It goes throughout the chain. That means market depth, that means theories of harm, but that also means, and I will not develop that, but it's really important, remedies. Because digital brings a number of challenges to our remedy policy in antitrust as well as in merger control. Thank you.
Thank you. Let's now turn to our fellow co-host for today's Enforcer Summit. Ms. Doshi, are the current tools and laws in the United States, are they enough to enforce antitrust laws against dominant players in digital markets?
Thank you very much, Rahul. Good to see everyone, and this is an excellent example of a lot of the tone and themes of partnership and collaboration that I'm going to strike. So in a word, yes. Plot twist over, the current tools that we have are more than sufficient. And so, Ms. Blizzard, actually, unsurprisingly, we often speak together and we often draw on similar stories and themes. And, she's exactly right. I dusted off looking back at the text of the Sherman Act recently in connection with the remarks that I gave on emerging technology and whether current laws were fit to purpose. And in that research, I realized that when the Sherman Act was passed in 1890, something else significant that happened that year was also that the stop sign was devised at the same time. And so the reason that that made me chuckle a little bit was to ask about what is it about our modern economy that can be answered by the parsimony of a statute that was passed in 1890. And I think Ms. Blizzard hit the nail exactly on the head, and which is the way that the Antitrust Division is also thinking about it, which is to say that the Sherman Act concerns conduct, it concerns power, it concerns impact, but it's not about facts. It is about facts in terms of its application, but it's not about industry. It's not about the idiosyncrasies of a particular point in time. The underlying implicit underpinnings of the Sherman Act remain just as relevant today as they existed in 1890. And one of the reasons we know that is because in 1890, Congress had the ability to be more specific. I mean, I'd point your attention to other areas of the United States Code. I don't know if anyone's looked at Title 26 with respect to how we define drug trafficking offenses, for example. Those are very, very specific. So Congress made an intentional decision to eschew particularity in favor of the primacy of the virtue of competition and the harm that monopoly wreaks on that type of competition. And that's a really important framing device in thinking about how and when we make decisions to bring Section 2 monopolization claims is being faithful to that purpose and intent, and to realize that the statute is both broad and flexible to cover our modern economy, different though it may be, and inconceivable as it may have been in 1890. I think we see that analog, as Rahul had mentioned. I come to this from a background in digital assets and cryptocurrency, for example, and I think that often when people say maybe there are limitations in terms of our interpretation of the Sherman Act from 1890 to today, I point them to this example that Title 31 of the United States Code also defines money and financial institutions. Again, concepts that were the idea of digital assets and cryptocurrency being inconceivable at the time that those statutes were designed. And so there is a fidelity to our analytical purpose in the statutes that we have available to us that it's our obligation to look at in terms of those first principles. And so the fundamental question that animates the division's approach to Section 2 is whether the conduct by a particular firm, regardless of industry, regardless of history, does that firm have monopoly power? And if it does, did it or will it have an exclusionary effect and cause competitive harm in the industry? And so in thinking about that, I was looking over Director General Gorsant's shoulder here to see, the name of our panel today is called Challenges in Monopolization Cases. And so certainly there's a lot to be said about the difficulties in the formula that I just laid out with respect to, is there a monopoly and did it and will it have exclusionary conduct and harm? But really, there's not exceptionalism to the monopolization case as distinct from any other type of competitive harm case. And the reason I say that is that there is a ubiquity to the fact that when a firm enjoys dominance and market power, there is just the underlying temptation and opportunity and ability to exert type of control that creates exclusionary conduct and that creates harm, right? One necessarily often goes with the other. I often think about, in thinking about how we at the Antitrust Division will litigate these types of Section 2 cases, think about that language from Microsoft that says, what exactly is that line between vigorous competition versus monopolization, between illicit conduct? And that's where, it's important, as Ms. Blizzard said, it's our obligation as prosecutors and as enforcers to bring these cases to courts. Because as she noted, and I think is incredibly important here to mention, there is often, the concept of precedent in the American legal system necessarily bakes in a concept of inertia. What came before is what will come now. But what came before and what will come now is informed by choices that enforcers make in terms of where and how, in terms of which cases to pursue and how you want to pursue them, or which facts end up being the most important. And so I think that's all the more reason to say that we are obligated, and I'm going to talk about criminal Section 2 here in just a minute, to dust off these tools in our toolkit and really look at this with fresh eyes, understanding that every presumption that existed against the government before may not apply in the facts and circumstances directly in front of us now. And so there is a real freedom and possibility in the idea of looking at the history of precedent and the history of the way that the parties and the judiciary has defined what it means to enforce Section 2, and taking a step back and saying, is this accomplishing the goals that Congress set forth for us in 1890? And so, you might be aware that earlier this year, the department filed a suit against Google in connection with its digital advertising business. And that suit very much, I'm going to stick to what's in the complaint, and the facts is publicly available, but that litigation very much encapsulates what I've been talking about, which is the idea that we have charged and we have alleged that Google engaged in a pattern of acquisitions that then cemented its market position, its market dominance, and that they used that dominance to then engage in a series of exclusionary acts that entrenched and expanded its monopoly power. And the ways that the complaint has a number of examples that will not surprise you, whether it's tying arrangements, whether it's flattening the marketplace of ideas with respect to certain deals and conducts. The facts, are as alleged in the complaint, as we would allege in the complaint. But the bigger story that I use that as an example for is to say that it's not, there's often, whether it's in a fraud prosecution or in a Section 2 civil case, there is often a tendency or an instinct, particularly and understandably if you're on the other side of the V, to say each exclusionary act or each piece of exclusionary conduct should be looked at in isolation. So I often, when I train other prosecutors, talk to them about how that's death by 1,000 paper cuts, right? Nothing on its own really is that harmful, but it's important to think about, and as we've alleged in the ad tech case, along with our partners at the California Attorney General's Office and many other of our valued state enforcement partners, that this conduct doesn't exist in isolation. It's mutually reinforcing. It informs itself, and that when we turn, as I started my remarks, to thinking about that competitive process and whether there is exclusionary conduct that harms, whether it's consumers, the process, the industry, that's the important framing that we're trying to put out to the world. Certainly, more tools would be better, but that's, and we're excited to look at what our European counterparts have in terms of their additional tools and what lessons there are with respect to that. But our existing tools are certainly more than sufficient to do the job at hand. They're fit for purpose as they were in 1890, and they continue to be today. One other thing that I wanted to flag with respect to thinking about tools is that, just in a very back of the envelope calculation, my team let me know that I think in the last 15 years for civil Section 2 cases, there have been less than 30 jury trials. Over 15 years, less than 30 jury trials that went to verdict. And so, as just putting ourselves outside of the circumstance of being prosecutors and enforcers, but thinking about that as the public, whether it's the American public or the public anywhere across the world, The types of monopolies that exist today have far-reaching, enormous consequences. And the idea, is that it's important for, in the right set of circumstances with the right set of facts, to have those questions put to the people that experience those monopolies. And so, that's an important thing to be thinking about in terms of reframing civil Section 2 enforcement, is that while criminal cases in the United States always get juries, it's important to think about, are certain cases the right cases to be in front of juries on the civil side. And so with that, I wanted to briefly transition to, certainly it's an important and interesting topic that the division has begun or has pursued criminal Section 2 matters, the two of which that you're probably familiar with. And again, I take a step back to 1890 to say, as Ms. Blizzard pointed out, that when Congress passed the Sherman Act, it passed the Sherman Act to both civilly and criminally prosecute these conspiracies and restraint of trade and monopolization offenses. The Supreme Court in Northern Pacific highlighted just how significant the Sherman Act was at that time when it noted that a comprehensive charter of economic liberty aimed at preserving free and unfettered competition as the rule of trade exists. And so what I'm here to say is that Section 2, just like Section 1, has always been a felony, and that for the first part of the 20th century, the division brought many criminal Section 2 cases. The fact that something may have been dormant for some time doesn't change its underlying status as a felony, and that the truth is that if Congress has declared it so, it is our responsibility to not usurp the will of Congress, that in the right facts and circumstances, we enforce the laws that exist on the books. And so you'll see that there is a real commitment that we're dusting off this particular tool to make sure that we're capturing and enforcing Congress's will, again, letting the facts and circumstances guide us. And so you might ask yourself, what are the right facts and circumstances? What factors make something a criminal Section 2 case, right? And to that I would say, again, coming at this from a perspective of other areas of law enforcement as well, there are often circumstances in which there is a civil and a criminal like parallel proceedings or parallel acts that are both criminalized and subject to civil penalties. And the way that you think about which tool is the right tool or what is the right set of circumstances is that criminal conduct exists on a plane that's distinct from civil conduct just in terms of the intent that often exists and the hardcore nature of the violation, right? That there is less ambiguity and more clarity around what the parties intended, how they effectuated it. You'll also see that there's, if you look back at the history of criminal Section 2 cases, there's other overt indicia of criminality, often marked by acts of violence, right? That's not to say that that's always required with a criminal Section 2 case, but that helps to sort of start to think about the history and evolution of criminal Section 2 enforcement in this country and where it's headed. And so, the last thing I wanted to point out is that certainly we'll use our prosecutorial discretion and the rules and standards that govern that with respect to making the decision between criminal or civil enforcement of Sherman Act Section 2. But it's important to remember that, there are different penalties and processes that exist in the criminal world. So for example, in a criminal Section 2 case, there's the availability of not just injunctive relief, but also treble damages, and then third, possible imprisonment for up to 10 years, right? And so taking that distinction in terms of remedies and then using that as a framing device also against the facts and circumstances, so that indicia of criminality that I was talking about, the focus on intent, that will shape how we look at the facts and circumstances to decide whether something is a criminal versus civil Section 2, and what will animate the types of criminal Section 2 cases to be brought by this division. Thanks very much.
Thank you. I know we're getting to the top of the hour. We started a couple of minutes late, so I think we have a little bit of flexibility, but we are coming to the end of our panel time. But I wanted to close with just some short questions for each of our panelists. And I want to start with Chairman Han again. Chairman Han, how would experiences in merger control be helpful to work in monopolization cases and vice versa? Okay,
In Korea, both enforcements have mutually influenced each other. which in turn enhanced the effectiveness of the tools for advocating competition. Constructing theories of harm is crucial when it comes to merger review, and the KFTC's experiences in enforcing laws on various abuses of dominance helps to enrich and solidify the theories of harm. Moreover, we realized the importance of taking ex-ante preventive approach through merger review and digital markets through our experiences in enforcing abuse of dominance. The Kakao case mentioned earlier in the presentation is a case where sanctions were imposed on a dominant platform for expanding its dominance even to adjacent markets through self-preferencing after acquiring small businesses in such markets. This case served as an opportunity for the KFTC to understand how platforms use conglomerate mergers to transfer dominance to adjacent markets. In addition, the KFTC plans to conduct a more thorough review of conglomerate mergers that involve digital platforms by amending guidelines for M&A review. Meanwhile, there are other cases where the KFTC successfully applied the innovation market approach, which was developed in the process of merger review to sanction big tech firms for their abuse of dominance. While investigating the merger between semiconductor equipment manufacturers, Applied Material, and Tokyo Electron, the KFTC defined the R&D sectors for next generation semiconductor equipment as separate markets and proved that such transaction would impede innovation competition. In another case where Google abused its dominant position in the OS market, the KFTC defined the R&D sectors for non-mobile OS market as the innovation market, and even imposed remedies on such market after successfully proving that Google blocked the entry of competing products since its developing stage.
Thank you. Thank you, Chairman. Ms. Blizzard, what's the most important thing for enforcers to remember when addressing novel fact patterns in monopolization cases?
Sure. So I think the most important thing to remember are many of the things that we've talked about today, which is that you have a ton of tools at your disposal. And not to burden you with too many quotes from the California Supreme Court, but I have one more. In a seminal case, Clayworth versus Pfizer, our Supreme Court said, quote, "It is better to over-deter antitrust violations than to under-deter them." So the most important thing to remember is don't under-deter. Bring cases. And just briefly, we bring cases in California state courts under our state laws. California v. Amazon is a good example of this. That's just us going against Amazon, bringing Cartwright and UCL cases. We bring them with the other states, without the feds. We are also delighted to join our federal partners in some of the Google cases. But we look across all of our options and we figure out what makes the most sense, where we can make a difference, where we have the resources, and we try and make sure at all times that we're not under-deterring.
Thank you. Director General Gerson, you spent a lot of time thinking about remedies. How do we know when remedies are effective?
Well, you have only really easy questions for me today. Well, you don't unless you evaluate, and that's the reason why we have decided to step up quite a bit our ex post evaluation activity. Mrs. Vestager has decided to appoint one of our fiercest enforcer, Mr. Dysenhofer, to do just this. And for me, the answer to your question is in systematic ex post evaluation. That's absolutely crucial.
And finally, Ms. Doshi, sitting here in Main Justice with all of our international partners, how does the Antitrust Division work with other enforcers around the world? And you had mentioned, criminal section 2. Can other enforcers refer matters to the Antitrust Division when they think there's criminal treatment, where they think criminal treatment is warranted?
Thanks. The short answer to that is also yes, please do. As many of you may be familiar with, President Biden signed an executive order that required us in the United States government to adopt a whole of the government approach with respect to tackling the competition problem. And so I often think about that in terms of an analytical framework for solving these problems, because as I said earlier, the Sherman Act isn't limited to boundaries, whether they're jurisdictional, whether they're industry or otherwise. And so I think it takes a whole of the enforcer's approach, a whole of the prosecutor's approach to be able to engage in collaborative information sharing as that's allowed and authorized, but also in terms of thinking about, what are the best practices that we've all gleaned from various forms of enforcement. So with respect to criminal Section 2 enforcement, certainly, but I also think that the partnership and collaboration is important. But writ large, I think that we're seeing that the types of competition issues that face our world are enormously complex, cross borders, and so we need to do just as good of a job of being able to cross borders ourselves and partners together as we have been historically. We look forward to doing that.
Thank you. Well, everyone, that is our time. I thank you for your indulgence in going over a couple of minutes. Thank you to our panelists for the thoughtful discussion. And thank you again to our audience, those here in person and those watching us on the live stream. We hope you enjoyed this morning's interviews with AAG Cantor and Chair Khan, along with our panel discussions on merger reviews and monopolization cases. More importantly, we hope you walk away from this morning's conversations with something new, a new insight, a new perspective, or even just a new fact. For those watching remotely, this concludes the live streaming portion of today's summit. For those here in person, we will now take a break until 2:15 p.m. Following the break, we will have our first small group coffee talk discussions where different tables will share thoughts on merger review, monopolization, remedies, and roll-up strategies. You will find your table assignments on an easel somewhere, I am told. Again, to everyone, thank you. We will see you back here at 2:15.